How is the camera on here? Because I'm not sure.
I see you just fine. Okay, we are letting everyone in. Okay, I think we have everybody here.
Thank you. I apologize, and I'll apologize.
Okay. All right. Good afternoon, everyone, and thank you all for joining us for today's month of service presentation of divorce and what to expect. I am Nia Murray. I am the programs coordinator with Neighborhood Recovery Community Development Corporation, and we are one of the partners in the A Month of Service collaboration. Also included is the City of Houston's Department of Neighborhoods, and typically joining us would be Miss Myra Hippolyte, but she is actually out of the office today. Also, on behalf of the Houston Bar Association, they are our collaborative partners as well. We have our presenter joining us today, Miss Judge Julia Maldonado, who's going to be presenting on divorce and what to expect. But also included in the partnership is Lone Star Legal Aid, the Earl Carl Institute, Houston Volunteer Lawyers, Harris Central Appraisal District, and the Harris County Tax Assessor Collector's Office. And together we make up A Month of Service. And for those that are unaware, what A Month of Service is a collaboration of these 8 different organizations that come together on a monthly basis and offer a variety of different workshops, resources, information to the community as it relates to community empowerment when it comes to legal matters, asset building and asset protection and the maintaining of generational wealth. So we know that there are a lot of folks out there that don't have access or don't know where to go for assistance or to have questions answered or even kind of where to start. So, so we collectively come together every month to offer a variety of different options for people and resources and that information. I also want to give the disclaimer that information that is presented here today is for educational purposes only. It's not to be considered legal advice. However, we do encourage you, if you all find yourselves in need of any civil legal assistance, we encourage you to reach out to our legal service partners like the Bar Association, Earl Carl, Lone Star, and Houston Volunteer Lawyers. With that being said, if you guys have any questions, please feel free to type those questions into the chat and we can try to get to those questions as quickly as we can. Please feel free to unmute yourself at the end of the presentation to ask your questions directly if you'd like as well. For those that are joining us, please be aware that we are recording the session as well as on Facebook Live. So we try to protect your privacy as much as we possibly can. So we ask that you try to keep your questions to be as general as you possibly can and not divulge any personal or detailed information about your specific situation. If there is a particular question that you have, please type it into the chat or send myself an email and we can make sure that it gets to our legal service partners to have them address on your behalf. So with that being said, thank you guys very much. We appreciate you coming back and attending all of our month of service presentations. We do apologize for the delay, but as you know, all of our legal service workshops are done by volunteer attorneys, and in this case, by the judge herself, who was in the middle of a court proceeding and stopped to present this information for you guys. So that speaks to the dedication of our presenters and our volunteers that do help in providing this information to the communities that we all serve. So with that being said, I'd like for Ms. Maldonado to go ahead and introduce herself, and we can move right on into the presentation because I don't want to hold you up any longer than what we need to here. We want to get you back to your court proceedings. So go right ahead.
Thank you very much. Thank you very much for having me this afternoon. And I really appreciate it. It's my honor to be here and to have such a great audience. I didn't realize there was so many different entities that would be involved in this. It is a great service to the community, especially with divorces. It's such a big field to actually try to explain on the divorces. It is a section of the law that affects many people, many attorneys, everyone in general. We always say, oh, it's never gonna be me, and that's not really how that goes. It affects many of us. either through a divorce or our grandchildren or something of that nature. Let me fix this just a little bit. Okay, so let me start with the divorce process, and I'm hoping that I don't go too elementary or too high above on what I'm supposed to say, but the divorce process, while it seems like it's not something difficult, it is, and not only is it difficult, but it's something very emotional to many people. Many people go and hire an attorney. Some people don't hire an attorney, and then they appear on their own here. The problem with the people that appear on their own is that some of them don't know exactly where to do or where to start. And so they put that burden on the court, and we cannot act as their attorneys. But there is many forms out there that are put out there by the Texas Supreme Court that have explanations on them. And so if they follow them, then they would be able to file what they need. But the divorce process, of course, starts with the original filing of the petition for divorce. And if you're filing in a specific county, like if you reside in Harris County, you have to have resided in Harris County for 90 days, the state of Texas for 6 months. So you can file here in Harris County at the time that you started the petition. So it's not that, oh, I will live in Harris County 90 days. It's at the time that you file your petition, have you lived in Harris County? Now, one of the main issues that I see in the divorce actions is including the children. People tend to forget that, yes, it is my husband's child, and we had that child 10 years ago, but you have to be specific when those children were born. Were they born during the time that you were married? Were they born after you became married? And is the paternity of that child established, or how is it going to be established? And of course, there's different ways of the paternity, how the paternity can be established. The easiest and the fastest way is if there is what we call, for sure, we call it an AOP, which is an acknowledgement of paternity of the child. Many times that happens at the time that that child is born. You know, mom and dad say, okay, this is our child. We sign that. And so that gives you the paternity. But we also have some that are a little bit more complicated, where the child is born during the marriage, but it's not of the marriage. Basically, it's not the child of the husband. It's someone else's child. So at that point, you can actually have in the same document, that we call, or we stated it to be an AOP, in the same document, that's what we call a DOP, basically where the husband signs and says, this is not my child. So it all gets taken care of. So that's the cleanest and easiest way to determine that. If not, then you would have to go through the genetic testing or other sections of the code that tells you how you can establish paternity. Now, we do have an issue with, and I guess in the past, when I was a practicing attorney, everyone would just say, oh, just serve by publication. So even after you file your document, you have to give notice to the husband or the respondents. Okay, so you can't just say, oh, I don't know where he is, I don't know where she is. At least in my court, we require an affidavit from the husband or the wife, whoever is filing the divorce, that says, you know, I don't know where he or she lives. I looked them up on Facebook. I looked them up in the Harris County Jail. I looked them up in the states. I've looked him up everywhere, and I can't find him. And this is the last place where we live together. And so I will require that you at least serve him where y'all lived together, or where the persons lived together the last time, or where they know the person lives, because many of them do have contact. For some reason, they think that it's easier to say, I don't know where the person is. It might be easier until the court has to appoint an ad litem to try to find that person. And I mean, an ad litem is an attorney that will look for the respondent, the husband or the wife that you were married to. And then that may end up costing you more. It may end up costing you, I don't know, a couple of $1,000s. It just depends on how much time is spent. I don't really know. And I can't really say, oh, a chat item is going to cost you this amount. But the person has to be given notice. Okay. And it's easier if you just serve them by a process server. They go find them, they knock on the door, here's your documents. He or she doesn't file an answer within the 20 days. If the case has been on file for 60 days or more, actually I say 61, then you can actually get and obtain a default. A default means that you're able to obtain your divorce without the other party being here. Okay. But in order to obtain a default, there's also some documents that have to be filed with the court. At least this court requires a certificate of last known address, meaning where did this person last live? And the court requires a non-military affidavit where you actually have searched whether or not this person is in the military. And then we also required an inventory and appraisement. And sometimes people think, oh, I don't have anything. I don't need to put that together. Even if you think you don't have anything, then you need to list, I have zero community property or zero property. And then that goes in the file, because the court can only distribute what the parties have. So let's say you say, I don't have anything, and then we grant the divorce saying neither party had anything. So nothing is really awarded to either party. Then the other party later finds out that the party actually had, I don't know, $1 million, okay, in whatever stocks or whatever, and they didn't list them on that inventory. Then they can come back and those monies would be later distributed between the parties. So the court can only distribute what you put on your inventory. It's also a very good idea in practice. Like if there's a home, let's say, and you're stating it's your separate property, say on there, it's my separate property, go find a copy of your deed where it was purchased before the marriage. And so that there is good information where the court can make a good recommendation that that particular property is your separate property. So that probably that very well takes care of the property. And the other thing, people always sometimes say, well, I don't know what he has. I know he has retirement, or I know she has retirement. Well, do you know where she works? Well, yes. Well, then your attorney or you can issue a subpoena to his job or her job regarding those documents. That way you have a better understanding of what's in there. Because if not, it makes it very difficult for the court to make a distribution when we do not have proper documentation to be able to make a proper distribution of the assets. Moving on with the assets, there's sometimes a need to do what is called a quadro, meaning to be able to distribute whatever there was or is in a retirement account. You have to have a qualified domestic relations order, and that order has to match the distribution that was made in your decree. So if in your decree you received 100,000 from your husband's or your spouse's retirement, then the qualified domestic relations order, the quadro, has to say 100,000. Now, if it's entered within the time that the court holds or has plenary power over the case, that quadro is just submitted, then it's signed by the court, and the case is done. What we experience many times is that that quadro is not filed within the allotted time, within the 30 days. And so when that happens, then you have to either obtain or file a motion that is agreed to with an agreed order, and then I can go ahead and sign that order or that quadro. If it is not, then a new lawsuit has to be filed, and you have to serve or basically give the other side notice. And by notice, I don't mean you go and give it to them yourself. You have to have a process server to take that notice to the respondent, that notice be filed back with the court, and then go through the process of filing to obtain another default to have that quadro signed. Now, the other thing that sometimes does not get filed along with the final decree of divorce is what we state as special warranty deeds. If one party received a home as part of the distribution in a divorce, then you need to make sure that all the documents pertaining to the home are filed also within the allotted time, so that you won't have any issues later on. Because many times the parties come back, or the attorneys come back, oh, he or she won't sign the decree. Well, it wasn't filed shortly after the divorce or with the divorce. So yes, you're going to run into problems with that. Okay. So you need to make sure that those documents get signed, or you receive enough time from the court to submit all the documents, including your final divorce decree, with ample time to be able to give you sufficient time to put the decrees together, the warranty deeds, the quadros together. And if many attorneys just send out their quadros out, there's various quadro companies that put those documents together. There's also sometimes it's just forms from the company, so you can get those forms from the company and get it approved by them, and so you're able to provide those documents to the court within the allotted time. Let's see, I see some realtors here, and I heard HCAT was also here. So proper wording on your final decree with regards to the distribution or sale of a home is very, very critical, because if you don't have the correct language on there, it'll make it difficult to be able to enforce any sale or any transfer of a home. I'm gonna go back a little bit on the child's issues, okay? That's something that you have to be very, very careful, as I was speaking to earlier. If the paternity of the child is not established properly, you may run into issues, whether they are issues with probate matters, or different kinds of issues that you may run into, especially if sometimes people or will file or sign an acknowledgement of paternity and later determine, oh, that's not my child. Well, there are all kinds of deadlines to be able to rescind those acknowledgements of paternity. And there's deadlines also for bringing actions to set aside those acknowledgements of paternity. But once you determine paternity, we have custody. And custody is something that is highly contested in many, many cases. with regards to the custody, you can have either a sole managing conservator or a joint managing conservator. People sometimes get really hung up on the sole versus the joint. Sometimes it is necessary. Sometimes it's really not necessary because the parents are both going to see the children unless there's some exigent circumstances where one of the parents should not be seeing the child. Okay, there's rights and duties that are according to the code that can be awarded to either parent or to both parents. One of the rights and duties that I think that a lot of us didn't really consider it to be that important is the right to earnings of the child, because we always think, oh, my child is never going to earn any money, you know. But the rights of earnings to the child come into play if your child becomes an actor, if the child is an athlete, you know, and they start earning money, or some kind of movie star, you know. So those rights are very, very important. But all rights are important. We have the right to determine the residence of the child. Basically, where is the child going to primarily live? Where is the child going to go put his head or her head down at night? But it doesn't mean that the other parent doesn't get or receive any rights to visit with the child. We have the code gives us various different scenarios and different possession and access. We have a standard possession and order, which is what standard meaning basically, and this is just very summarized, okay? Your child is picked up at 6 on Friday and returned at 6 on Sunday on the 1st, 3rd, and 5th Friday of the month. And when we're talking about the 1st, 3rd, 5th Friday of the month, that makes it easier for a court to enforce this order. Meaning if one parent is not allowing the other parent to visit with the child, it's easier for the court to keep track and be able to determine, okay, was it the 1st Friday of the month, and did that person appear at the time prescribed or order on the order? And so it's easier for the court to make that determination. Many times parties entered into different kinds of orders. I don't know, we're going to have them 6 days or 7 days or every other week. And so in order to be able to enforce that, sometimes you have to go back to the very beginning of the order and list each of the possession and access to be able to determine if the other party was in violation of the order. So it makes it a little bit more difficult when they come up with these different kinds of possession and access. And we have to keep in mind that it's what is best for the child. It may not be the best thing for the parents, but it's the best possession and access of this child by the parents. It's the paramount question on here, and so we have to make sure. I also see that Lone Star Legal Aid it's present. So at times in determining the custody of the child, of course the court looks at if there is prior violence in this case, and who is the violence against, and is there a conviction, is there protective orders? The court looks at all of that, and it's easier if y'all obtain certified copies of those documents instead of, I heard there is such and such thing. It's easier to say, okay, I have a copy of a protective order and it's filed with this case, and therefore I'm asking X, possession and access. And so that makes it a whole lot easier for both the court and for the parties to be granted what they are asking for. there is an extensive amount of rights and duties that are under the code. All those rights and duties can be restricted by the court if it's not in the best interest of the child. So you have to look at all the various rights and duties that are available. And I could start telling you the different codes, but I don't necessarily think that it's, I'm sure that y'all can look up the different sections of the code. And you can read through them and say, okay, should we restrict or ask for some of those to be restricted? Now, let's see, what can you expect when you come to court? There's all kinds of things that you can expect. The one thing that you can expect, and at least in my court, we're going to go through your case. We're going to make sure that what was filed should be filed. If it's not requested, or if the law does not allow me to grant you what you're requesting, then of course it's not going to get granted. But if your pleadings, meaning your request, is made correctly, if you serve the person correctly, and if you have all your necessary forms, you can actually get a divorce that, you know, like I said earlier, 61 days. I want to make sure that I mention that sometimes, or many a times, the person asking for a divorce requests what is called a waiver of service from the other party. Okay. You have to make sure that your waiver of service, it's not signed on the same day that you file your divorce decree, that it's at least signed the day after, that would be okay, but that it's a complete waiver of service. It requires an address, a full name and a full address. If it doesn't have the address, then it won't be a proper waiver. Okay. So look at the date. Sometimes I get waivers here that are signed by the party and they're not notarized, or they're notarized and they're not signed by the party, or they're filed on the first before. Let me rephrase that. They are signed before they even filed the divorce, which you can't do. But if a party comes in, you file your divorce, you, instead of serving the person, you obtain a waiver, and the waiver is correctly, it states the person's name, it states the style of the pleading that you filed, meaning the document that you filed. Most of the time they'll be titled original petition for divorce. So if it says I'm waiving my service to an original petition for divorce, and if it has the name of the person and everything correctly, then more than likely you will be granted a divorce, but a final decree of divorce. In this court, in the 507, we're making it a standard that everything we do here has a record. So our final divorce decrees will always say that a record was taken by the official court reporter of the court. So that in that way, or in that manner, if there's ever any question as to what happened on that specific hearing, you can always ask the court reporter, and you pay for the record, and you receive a copy of exactly what was said and exactly what happened in a proceeding. So if you're looking for a case, and it could be anybody's case, your case, if you look at the docket sheet, meaning the notes from the court, if it says there is a record and it has a court reporter's name on there, then you can request a copy of that record, and it will tell you exactly what happened during that specific proceeding referred to on there. Let's see. Now, the majority of the times people ask, am I going to get a copy of it? That's not something that the court automatically sends out. So if you're granted a divorce and you were here on your own, then normally I tell them anywhere between 7 to 10 days, and I only give that time frame just to make sure that it's already processed. But you can request a copy, a certified copy. You can either come to the district clerk's office, or you can order one online. And that's a certified copy of the decree. The other thing that I don't want to forget is in your decree, you can ask for a name change, but you can only ask for a name change to a name that, you know, your maiden name or a name that you had previously used, and not, okay, now I want to completely change my name. You can't completely change your name to something else. I was Maria, now I want to be Julia, and I can't do that. Now, if I was Julia before, then I can change it to Julia, but not to something else. Because if you're changing your name to something totally different, then that's a different kind of pleading, a different kind of request, which requires it requires a criminal record from the state. And so those are not had on the same pleading as a divorce petition. Now, we also have enforcements, and enforcements can be either enforcements of a section of the suit affecting the parent-child relationship, which is part of the divorce, or it can be an enforcement of anything else that was on the divorce petition. And I'm going to go back because I think I didn't mention this. The divorce and the section of the children in Texas, they both go together. It's basically two lawsuits together. If there's children, they're always going to be in the same decree. Of course, this is your divorce. The children is called a suit affecting the parent-child relationship. So the suit affecting the parent-child relationship with regards to the children, that can be amended, changed, enforced up until the child is it's emancipated. So I'm going to go with the modification of a suit affecting the parent-child relationship. Okay. Let's say at the very beginning of the final decree of divorce, the child stay with dad. Okay. Time passes. Mom is now earning more money. So dad can come back to the court and ask for a modification of the child support, either to increase it or decrease it or whatever that other person wants. Now, mom was working very well at the time the divorce happened. Now mom is no longer working. Mom was dismissed from her job, or mom is now ill and she's no longer earning what she was earning at the time of the decree. Well, mom can also come back to the court and file a modification and ask for her child support to be modified or changed. And that goes for whether mom or dad had custody. So if mom had custody, dad can also, if the same things happen to dad, that can come back and ask for the court for a modification, which is either reduce or increase the child support. You can also, let's say the child, all of a sudden, dad left the child with mom for a long period of time. You know, dad can't handle the child, and he goes and leaves the child with mom for 6 months. So now mom can file a modification to where she would have custody of the child and dad would be paying child support. So those are just some examples of ways that you can modify the orders. And modifications of orders happen throughout the period of time that the child is not emancipated. So, and they return to the same court. We call it court of continuing jurisdiction. So if a case ended, a divorce ended here in this court, any changes to the SAPSR or suit affecting parent-child relationship of that divorce will always come back or be filed here in this court. So it doesn't matter what court you had. If your court ended up in the 257th, though any changes go to the court. If your divorce ended up in the 245th, any changes will be to the 245th. So those orders can be changed at any time. Now, sometimes people say, well, but I've had my child for 2 years in my custody, and I'm still paying child support. I've always paid child support. My child support, should have stopped, but they didn't do anything to try to stop that. So the court can only look at the time that you file your pleading to modify it and what are you actually asking for, when are you asking for it to stop? What are you actually stating in your petition? What are the reasons why it should stop and how far back it should go? And then we look at the law, we look at the test, we hear the testimony, and we hear the evidence that's presented. Then we make the determination of how far back should it have stopped or when should it have stopped. So those just are some issues on the modifications. But there's all kinds of things that can be modified. There's times when the parties didn't address the passport situation at the time of the divorce. So it's not there. It's the divorce, it's silent, because I think the divorces in the past few years did not address that. And now you want to change that and your spouse doesn't want to agree to it. So the only way you're going to be able to change that is to come back to court and do a modification to address the passport issue or any other issues that might have been left off. Okay. Now I'm definitely going to move to the enforcements. Enforcements, you can do enforcements of child support, enforcements of possession and access when it comes to the children. I've seen enforcements of injunctions that were placed on the final order. For child support and possession and access, the opposite party or the party that is in violation of the order could be placed in jail for each violation. So, and then that party is entitled to a trial by jury if the party bringing the action is asking for more than 6 months in jail. I have been here on this bench. This is my 7th year, and we have yet to try an enforcement to the jury. Most people fear to be placed in jail for violating the orders. And so many of the cases are end up in agreements where they can come up with a happy medium to resolve the issue. Now, if I tried the enforcements are a little tricky when you are putting together an enforcement petition, you have to look at on how you put your petition or your pleading together, because you have to look at your violations. And now this goes back to the original drafting of the final decree. If it wasn't drafted correctly, you might have a difficult time putting the enforcement petition together and actually being able to prove that the person did not appear. Let me see if I can think of a good example of this. Sometimes they'll just say, you pick them up at my house. So it doesn't have an address. So if you are going to file a petition for enforcement for not allowing you to see the child or the children, and he was supposed to pick up at the house, that petition that the move-in brings is going to have to probably mention several sections of the order. If my house, and then where is the address on what page, and what time was I supposed to show up? So just look at your final orders to make sure that they are where they can be enforced, because many times they are not able to be enforced. The same is for the child support. Okay. Was it supposed to be paid on the 1st? Was it supposed to be paid on the 15th? What day was it supposed to be? I've seen orders where they state, oh, he's going to pay me every week, but they don't put a date. Is he going to pay me on Monday of every week? Is he going to pay me on Friday of every week? And now you're trying to enforce that petition. That is going to be a bit difficult to enforce. So while the person may not be paying you, you may not be able to enforce that petition. So look at your motions very, very closely. All petitions, whether it's the original petition for divorce, your modifications, or your enforcements, they have to be served. They have to be served by a process server unless you have a waiver. On the enforcements, if you actually want to put someone in jail, that person has to be served in person. You can't just say, oh, I accept the service, or I accept the service for so-and-so. You have to actually serve the person to be able to enforce and be able to put that party in jail. Let me see. That is the process of the divorces. Let me see. In my court, you actually have to prove up your divorce. This court doesn't accept affidavits. At one point during COVID, we were accepting affidavits for a prove up. Okay. And so that is no longer acceptable. Now you have to appear for what is called a prove up. You can come in via Zoom for anything that it's agreed. If it's not agreed, it is required to be in person. We have sample prove ups on how to prove up your own divorce, especially if you're doing your own divorce. And if you don't have those questions, I'll refer back to my original mentor from many, many years ago when I first started practicing law. You use your petition, the original paper that you filed, and you just go through each individual item and ask, like the very first page, it says, I'm the petitioner. So you'll just say, my name is Julia, I'm the petitioner, and that's actually what your petition is going to say. My husband's name is so-and-so, and we were married so-and-so. So all that will be on your petition. So if you are doing the divorce by yourself and you forget on to download the prove-up questions, you can always use your petition, or most courts have a sample prove-up that we have. Of course, you have to modify it a little bit if you have children or you don't have children. In the custody section, where there is child support, in order for withholding child support from the person who is paying child support from their job is required. It is just, it's a form that you completed. The one section that even the attorneys forget is the section where you have to list how much it's per week, bi-weekly, bi-monthly, and per month. If you have difficulty trying to figure that out, just look on Google. It'll tell you how to figure those out. It's okay that the child support states, I don't know, $1,000 per month. It's okay, but you still have to list on there how much it would be per week, bi-weekly, bi-monthly, and per month. It's just required. And that same form also has a line item if there is a reimbursement of medical. So if the parent who is paying child support is providing insurance at his or her cost, there is normally not a reimbursement. But if the parent who's not paying child support is the one that is carrying the insurance, there will be a reimbursement of the cost of the insurance, but it's a reimbursement of only the cost for the child, not for the child and the mother and the other 5 kids. No, it's only for the number of children for whom the child support is being paid. Now, if the child is covered by Medicaid, normally the Office of the Attorney General will intervene and they will ask for a reimbursement. If they don't intervene into the case, if they don't make themselves part of the case, the court will still order an amount to be reimbursed to the state for the amount for the Medicaid, not the amount. We can order up to 9% of the obligor's wages, but we also look at all kinds of circumstances to determine the amount. Normally, the amount, it's anywhere between $50 to $100 per child on Medicaid reimbursement. But we look at the parents, the children, how much they're making to be able to determine how much they should actually reimburse the state. And many times it's a lot less than what would be required if you had to purchase insurance for a child. I don't know if we have any insurance agents here, but we all know that insurance is pretty high right now. So the children that are being covered by Medicaid and the other parent is only reimbursing, $75, $100 per child. It's not a whole lot. Now, most parents will have to cover 50-50 of anything that's uninsured. So if it's not covered by the insurance that is being provided, then both parents are normally responsible for anything that is not covered under the insurance. Any other agreements that the parties make, it's entirely up to them with regards to the children. Sometimes parents will agree to child support over and beyond the 18 years of age, or they'll agree to cover the college tuition, or to purchase life insurance to cover any child support not payable if the parties, if something happens. So, but the parties can agree to other items as long as if they're in agreement. The court can only order those things that the law indicates that we can. Otherwise, we will not do those things. There are children that may require child support beyond the 18 years of age, especially if there's some kind of disability, and that disability is known at the time that they're 18 or younger, but it has to be pled for. So someone may be paying child support for the lifetime of the child. Of course, there's many other variables that you have to look at. And normally you might need to look into an estate planning on that, because the child may or may not be able to qualify for Medicaid or other kinds of benefits that are out there after the child is 18. And if the child is receiving child support and not properly placed on the order, then it may prevent the child from qualifying for benefits that he or she may be able to receive. So you have to be very cautious and make sure that there's plenty of research on that before the agreements are made with regards to children and their support after they're 18, and who's going to take care of them, because some of those items may be going through the probate court under guardianships and not necessarily in this court. It just depends. Let's see. I think that's the majority of what I have with regards to the children and to the divorce process. But you do have to come in and request it and prove it up before anything is granted. Then make sure that there's proper documentation on the and any assets that they have, especially if they have many assets and you're trying to default someone. I had a beautiful default probably a few months ago. It was a very extensive property case, and of course their inventory, every item on the inventory, I had a supporting document for it for me to be able to make the proper determination of how much, if anything, the other party would be receiving. So it's my suggestion on an inventory, place supporting documentations. It will work wonders for you. That way there is no doubt whatsoever. And make sure that your finalization documents, as your warranty deeds and your quadros, are there. And then let me make sure that I go back onto the requirements on protective orders. If there is protective orders against one of the parties, make sure that that is mentioned in the original petition. Make sure you attach a copy of it so that the court is aware of exactly what is being ordered on that protective order. If there is any conflict, some of us may change that, because I know that we have seen a few orders here and there where there has been temporary orders of support. Those may differ once they come to the district clerk, the district court. Miss Murray, Miss Mia Murray, is there anything else that you all would like for me to cover? Because that's what I have. I say summary, but let me make sure that if there is any attorneys, and I don't offer it via Zoom, Ms. Murray, but every Friday morning from 8 to 9, unless it's a holiday or the courthouse is closed between 8 and 9, we do a review of family law every Friday. And I have attorneys that are welcome, because it's a CLE, and I haven't opened it on Zoom, but that's something that I could consider in the future, because it's very informative to everyone who has questions on that. Now, the DRO, the Domestic Relations Office, right now is actually reviewing petitions and all documents for pro se parties, meaning those people who are representing themselves on these divorces, so that if there is an issue, they can help you correct it before you actually come to the district courts, the district court, because otherwise you'll come here, we'll find something wrong, we'll send you back, and you'll be back and forth until that's corrected. And sometimes I know people get frustrated, but the fact is that we can only grant what the law allows us, and the petitions, the documents have to be correct. And so you might get frustrated coming back and forth if you're doing it yourself. So sometimes it may be easier if you go to the domestic relations office and they review your documents, and then you come to the district courts.
And again, I just want to remind everybody that this session is being recorded, and I will be emailing a link of this recording to everyone that has registered. And I can also provide the link and the information for the Domestic Relations Office if there are any participants that are interested in representing themselves, so that they can get assistance in that regards as well. So I know you have to get back to court.
I want to make sure that they know that the various law, that we have 3 law schools here in town. The law schools all have a legal clinic, and so they provide assistance also with the cases. And of course, we have the HBA, the Houston Volunteer Lawyers, and they all provide assistance. One thing that I may have forgotten, if you have parties who don't speak the language, then you have to bring your own interpreter, and it has to be a certified interpreter.
All right. I don't have any questions. Nobody put questions in the chat. There were only a couple of random questions that were emailed.
You can ask the questions, not a problem.
Let's see, is there? Someone asked about parties that were married in another state that are now living in Texas. Do they have to file the divorce petition in the state where they were married, or now where they currently reside?
It doesn't matter where you were married. It doesn't make any difference. As long as you reside here in Harris County for 90 days and in the state of Texas for 6 months. So you have to have lived in Texas 6 months. And then in order to file it on a specific county, you have to be in that county 90 days.
Okay.
So,
I had a question, because I've had other friends that have gone through divorces and going through different disputes and things. When it comes to the division of marital
estates,
if someone has like a retirement or something like that, is there a set period of time that you have to be married in order for a spouse or soon to be ex-spouse to be able to benefit from retirement funds?
yeah,
Retirement benefits?
and I didn't get into separate versus community property, because that's very extensive. But if you have a retirement, the retirement, it's up for distribution. Okay, now the court will, and if proper documentation is provided, sometimes people they entered into an employment before they got married. So there's little formulas that we have to use in order to determine how much retirement is actually community and how much is separate. Okay, then the parties can agree to either split whatever is that is community or not. And if y'all don't agree, then the court gets to distribute that. But we have to determine what was during the marriage, because the court cannot distribute anything that was separate property. We have to confirm it as separate property, but y'all have to prove that it's separate property.
Okay. A question that was just said to me: how do you get sole custody or guardianship of a child if you cannot find the father?
Okay. There's all kinds of ways. You have to file your petition, but you know who the father is. Okay, so you still have to put the name of the father, and you have to do an affidavit of, you have to have known the person somewhere. Okay, it's possible that you know the mom, the brother, the sister, somebody. And so you do an affidavit of where you have looked at. If where did he reside last time that you knew him? Where is his mom? Where is his brother? Where did he work? or if you know where he's done it, where he has lived, or any of those items, then you list them on your affidavit, and you have to attempt to at least serve that person at their last known address. Now, if once you attempt to serve that person and you can't serve them, there will be an affidavit from you and an affidavit from the person that attempted service. Okay, so then you have to file a motion for substituted service, which those are granted only if we have the proper documentation indicating due diligence. And then Ms. Murray, I go back to then you're going to be probably having to pay an attorney that the court appoints for that person to find that person.
Ooh.
Exactly. So it's easier if you try to find them first.
Wow.
Well,
Okay.
it'll be cheaper. Let's put it that way. Sometimes people think, oh, it'll be cheaper if I just say, I don't know where he is. Well, it doesn't, it used to work that way in the past. It doesn't work like that anymore. And when I'm talking about in the past, I'm probably talking, I don't know, 20 years or so ago.
And we take a little bit deeper dive into the child custody and child support topic next Tuesday at 1 p.m. So if you want to tune in next week for a little bit more in depth, then please feel free to come back for that as well.
Next Tuesday on child support.
Yes, next Tuesday on child support and child custody for all of the participants here.
Okay, and that's at 1 o'clock.
Yes, ma'am.
Yes, if you could send me the link, I'll tune in next Tuesday at 1 o'clock on child support. Yes, that's a hot topic. It always is a hot topic.
It is. We last month we did just basics of family law, and then there were more questions after that. So then we got into the divorce, and then of course after divorce, there's more into the child support and child custody and things of that nature. So it kind of keeps leveling down and leveling down.
Yes, and one thing that I didn't mention on the divorce, you always put the date of the marriage. Sometimes people have been together for many, many years and represented to others that they were living, that they're husband and wife. And so sometimes a divorce can be filed by people who never actually went before a judge or before a priest and got married. That's what's called common law marriage. Sometimes there's also could be a divorce when, let's say you get married, you thought your husband was divorced, you married him, and all of a sudden when you're coming to a divorce, you find out that he was already married before he married you. So that you still could be a putative spouse, and you could still, but you still have to get a divorce as a putative spouse. So there's all kinds of issues that can come up. So I'd be more than happy to tune in next week. And my apologies, I do have to get back to my hearing.
Okay.
I wish I had more time to spend with y'all, but we'd be more than happy to come back at another time.
Definitely. Thank you for taking the time out and stopping your proceedings to address the participants here today. We really, really appreciate it. So thank you very much. If there are any other questions that anyone has about divorce, please feel free to email those questions, and we'll make sure that we get them out to our legal service partners to have them addressed. But again, next week, we'll be diving into a little bit deeper with child support and child custody, if you'd like to tune in there. Tomorrow, we have our Understanding Credit as part of our Money, Health, and Wealth Financial Capability Series. And on Thursday, we are doing our monthly will and estate planning and why you need it, wills and advance planning and why you need it. So that session is at 1 o'clock on Thursday. So there's a little bit of information that's kind of provided in there when it comes to spouses and estates and things like that when there are assets that are involved when someone actually passes away. So if you guys have questions about that or concerns, then you definitely want to tune in to that session on Thursday to hear that information as well. But again, Judge Maldonado, thank you very much. We appreciate on behalf of a month of service. We want to thank everybody for joining us again for today. And as a reminder, I will be emailing this recording to everyone, or if you'd like to go to our Facebook at Amos Houston TX, then please feel free to tune in there as well for the live sessions that we do host here every week. So thank you very much.
Thank you very much.
Enjoy the remainder of your day, and you guys take care of yourselves and stay safe. We'll see you all next time. Thank you, Miss Grace. Thank you, Roberto. And Anna. Oh, okay.